students. I am Professor Dr. Vidyapeeth, Director Faculty of Law and Governance. Today's our topic is kinds of work. So, shall we start our today's session? सेशन स्टार्ट होने से पहले मेरी एक हम्बल रिक्वेस्ट है स्टूडेंट, घर पे रहिए, हैंड्स रेगुलर वॉश करते रहिए, प्लीज स्टे हेल्दी एंड स्टे सेफ. सो shall we start today's our topic, kinds of work. Under Muslim law, work has been classified into two categories. Public work and private work. Public work. A public work is one for public, religious and charitable purpose. Private work, it is one for the settlers' own family and descendants, and it's technically called work ulal ulad. However, it is a family settlement by way of work. Work Act 1913, इसके मेन फीचर्स थे कि a Muslim can tie up his property in perpetuity for the purpose of supporting his family and children, provided that he makes a provision that the ultimate benefits should go to the charitable object of a permanent nature. Under this act, it is not necessary that there should also be concurrent gift to charity. A Muslim need not provide for any gift to charity until after the extinction of the whole line of descendants of the settlers' family. According to this act, a Hanafi Muslim can't enjoy the whole income or a life interest in the income of the trust property. He can only share in the income by way of maintenance. The objective of the act is explained under section 3 of the act. It states that it is lawful for a Muslim person to constitute a work which is all other aspects in accordance with the provisions of Muslim law for the following purpose. Write down: for maintaining and supporting his family, children, descendants, wholly or partially, Correct? If a person who is creating a work which Hanafi Muslim also for his own maintenance and support during his lifetime or for the payment of his debt or of rents and profit of his property dedicated. The statutory and administrative control of work in India. There are certain enactments which are provided for the creation and protection of public endowments. Some of them are write down Charitable Endowments Act 6 of 1890, Official Trustees Act 2nd of 1913, Religious Endowments Act 20 of 1863, Section 92 and 93 of the Code of CPC 1908, Charitable and Religious Trust Act 24 of 1920. These थे some important acts. समझ में आया? अब हम नेक्स्ट इसके लिए इसके अंदर ही टॉपिक लेंगे कि मोड्स ऑफ क्रिएशन ऑफ वर्क. Work can be created by the following modes. By an act, inter by voice. It means being living voices, that is during the lifetime. A work under this mode which is constituted during the lifetime of the work, if and takes effect from that very time. By will, it is contradictory to the work created by an act inter by voice, which means that it take effect after the death of the work. If during death or illness, जिसको कहते हैं मर्जुल मौत, आगे हम डिटेल पढ़ेंगे इसमें, as the gifts are made while the donor is on the death bed, it will operate till the extent of 1/3 of the property without the prior consent of the heirs by immemorial user. Work property can be established by way of immemorial user, although limitation of time also applies to the creation of work. Completion of work. The question as to how a work is completed may be studied from the following two angles. Number one, where third person is appointed as the first mutawali. Number two, where founder constitutes himself at first mutawali, जिसको आप कहते हो मैनेजर और सुपरिंटेंडेंट. समझ में आ रही है? लीगल इंसिडेंट्स ऑफ वर्क, पता है आप लोगों को? सबसे पहला तो irrevocability. The view of Abu Hanifa is that waqf can be revoked by wakf unless the declaration has been confirmed by a decree of a court. But Abu Yusuf takes a contrary view and holds that a declaration of waqf is in its nature irrevocable. The opinion of Abu Yusuf is followed in India. Inalienability. As the waqf property belongs to God, no human being can alienate it for his own purpose. Perpetuity. It is an essential condition of waqf. A waqf for limit period is invalid. Pious or charitable use of usufruct. The protect and benefits of the waqf property are utilized for such purpose which are recognized as religious, pious, charitable under Muslim law. Absoluteness. The settlement of the property in waqf is absolute. A conditional or contingent waqf is void. Clear? इसी में एक राइट डाउन कीजिए डॉक्ट्राइन ऑफ साइप्रस. दैट वर्ड साइप्रस क्या मतलब होता है? इसका मतलब होता है अ नियरली पॉसिबल. The term is essentially applicable to trust and in its technical sense means that if the wishes of the author of a trust can't be carried out, literally they will be carried out as nearly as possible in the way desired by the author. This doctrine is applicable to waqf also in cases where it is not possible to continue any waqf because of lapse of time or changed circumstances or legal difficulty, or where the specified object has already been completed, then the waqf may be permitted to continue further by applying this doctrine. So students, I hope all of you have understood. If you have any doubt, you can ask. You can ask me. आप मुझसे पूछ सकते हो. You can write me. लिख सकते हो. Feel freely contact to me. I will tell you some important questions for the examination purpose. Question 1. Explain the doctrine of Cyprus. Question 2. Explain the legal incidents of waqf. Write modes of creation of waqf. Explain completion of waqf. Write the short note on Waqf Act 1913. What are the kinds of waqf? very important question for the examination purpose. So please carefully study करना, और कोई भी डाउट हो you can ask me. Thank you students. Thank you for listening me.